The next panel is on ethical issues, and I think you'll find that some of the questions that were raised just before we broke for lunch will be canvassed perhaps from a slightly different perspective in this next panel. I should first of all apologize to you that Clay Powell is not able to be with us today due to another commitment that he has out of town, so I'm going to try to pinch hit for him. And fortunately, I have some very able assistants this afternoon. On my right is Alice Crawford. Alice has been with the office of Austin Cooper since 1959, so obviously that will tell you that A, she's very knowledgeable, and B, that she's a real asset to Mr. Cooper. In that period of time since 1959, she's watched the firm grow from Mr. Cooper as a sole practitioner to an office that is now comprised of 5 lawyers and 1 student. And you earlier today met one of the partners, Stephen Skurka. The firm is now Cooper, Sandler, West, and Skurka. To my left is Stephen Waisberg. Stephen was called to the bar in 1975, and for approximately the next 16 years, he was in private practice, specializing to some extent in both criminal work and young offenders work. Since the fall of 1991, Stephen has been a counsel with the Discipline Department of the Law Society of Upper Canada. Hopefully none of you have encountered him in his professional capacity, but he's here today to try to give us some guidance on the ethical problems that can develop and can confront support staff who work in criminal law firms. I'm going to suggest to you that rather than trying to answer questions from the floor as we go along, that we set aside 5 or 10 minutes at the end of the panel to deal with any questions you may have. And I think the reason for that will become apparent to you. We've tried to construct a number of case scenarios for the panelists to try to grapple with, and it may be easier for you to follow the flow of the scenarios if we try to do that uninterrupted and then come back and deal with any specific questions that you have. So I'm not discouraging your questions by any means. I'm just suggesting that maybe we hold them in this case until the end of the panel. Stephen, my first question deals with an area that other people have posed, and that is, what can support staff tell clients or prospective clients who phone in with problems? And the specific scenario I have for you is that a prospective client telephones the office, speaks to the lawyer's secretary because the lawyer is not available, and tells the secretary that she has been stopped on the Don Valley Parkway as a suspected impaired driver and is wondering whether she has to take the breathalyzer test that has been proposed to her by the police. What should the secretary tell her about that?
Well, I think from a practical point of view, I think you can assume that the police officer probably has indicated to her that it is an offense if she doesn't blow, or he doesn't blow. But in any event, it is not your function as support staff to give legal advice, and I think you have to advise her that is the situation. I don't think you can advise her as to whether you can blow or not, because I think you are giving legal advice at that point.
Well, Alice, let me pose the next question then to you. The father of a young client telephones the office and tells you that he has just found in his son's bedroom a letter which indicates that the son has hired the lawyer for whom you work to provide legal services. The father is very upset about finding this letter and wants to know, why does his son need a lawyer? You, in fact, know that the son has come to the lawyer because he's been charged with possession of marijuana and that he's hired the firm to represent him in court. What do you say to the father, and does it make a difference to you if the father says, well, if my son is in trouble, I'm the one who's going to be paying his fees and I want to know what's going on?
Well, we talked earlier today about confidentiality. The son is the client, and even if the father or mother or whoever pays the fee, it really has nothing to do with who the client is and the confidentiality. We talked about this in our office yesterday, and one of the lawyers said, you really don't even have to say to the father, the son has retained a lawyer. You really just say nothing. And you can say to the father, I can say nothing to you. If the father wants to call the lawyer, that's fine, it's up to the lawyer. But the secretary or the support staff can't tell the father anything.
Stephen, let's assume that Tom is a law clerk in a local firm which has been hired by a nurse who is accused of murdering babies at the local children's hospital. The case has attracted a lot of media attention and publicity, has been on the front page of all of the newspapers, and has generated a great deal of public interest. At a cocktail party, Tom is overheard telling his fellow guests that the nurse, who is represented by his law firm, in fact is going to be pleading not guilty at the trial because the defense has turned up some exciting new evidence that shows that the deaths of the babies were accidental. Has Tom done anything wrong by discussing the case at the cocktail party?
Well, in the context of his principal's law firm, he certainly has. I mean, I am discipline counsel. I don't have any mandate over the support staff, but I do over the lawyers, and clearly I would assume that any lawyer hiring support staff will advise the support staff of certain very fundamental requirements that must be maintained in a law office, and not just a criminal law office, but any law office. And client solicitor privilege is fundamental and very important. Tom simply should not talk about cases in the firm. Yes, he's done something wrong. And it may be something that will impact on his principal. The other thing I point out, and I mentioned it briefly in my paper, short as it is, that you may be in a situation where a lawyer may have cause to end your participation with the firm on something like that.
Someone related to me while we're on this topic that while she was on the subway coming down to the program today, she overheard two individuals who appeared to be lawyers talking quite openly about their respective clients. So I think we can all see how easy it is to get drawn into a situation where outside of the office, in fact, you're discussing client matters with third parties, and as well, if you have been involved through your firm with cases that have attracted media attention, you'll also appreciate that people generally want to know from you. They've read in the newspaper that the lawyer for whom you work is involved in this high-profile murder case. They want to know from you, what's the inside story? Is the person really guilty or really innocent, or whatever the case may be? And you have to resist the temptation that we all have to talk about our work publicly, and it can become very difficult at times when people draw you or try to draw you into those kinds of discussions. But as Stephen has pointed out, you have to be alert to the fact that not only may there be ethical problems in you doing that, it may create difficulties for you within the workplace and for your principal as well.
Can I add one more point?
Certainly.
Again, I think to underscore how important that principle is, you should know that even in a situation where the lawyer is fired by his client, the client loses confidence in the particular criminal lawyer, perhaps after the preliminary hearing, and decides to go to another lawyer, or in a situation where the case has now been completed and it makes the newspapers or whatever. In either situation, the solicitor-client privilege remains. You're not at liberty to talk about it, even if the client is no longer a client of the firm. The only time that would be discharged is if the client discharges it.
Let's move on to a slightly different and also very common scenario, and that's the matter of disclosing lawyers' fees. Alice, what if a potential client calls you and tells you that he'd like to come in and hire Mr. Cooper to defend him on his recent charge of impaired driving? The client wants to know before he decides whether or not he'll actually come in and meet with Mr. Cooper, whether it's going to be worth his while, in that he's not sure he can afford Mr. Cooper's fees. So he asks you over the phone what Mr. Cooper usually charges to defend a case of impaired driving. What would you tell that potential client?
Well, in our firm is the policy that the client speaks to the lawyer. I would tell the client to speak to the lawyer unless the lawyer has said, okay, we have a block fee for certain things, and you could be at liberty to tell the client that, but I would never, ever quote a fee to a client for anything.
Stephen, let's change that scenario so that now the same client calls, but this time he says that in fact he has obtained a legal aid certificate for his impaired driving case, and he's heard of Mr. Cooper and his reputation, and he knows that Mr. Cooper perhaps wouldn't usually take an impaired driving case on a legal aid basis, but to sweeten the deal, he's prepared to provide Mr. Cooper with an additional cash bonus in return for doing him the favor of taking his matter on. What should Alice tell the client in that scenario?
Well, she would tell the client that Mr. Cooper will not be taking a bonus if it's on a legal aid certificate. I mean, the client may misconstrue what legal aid is all about, but certainly Mr. Cooper would not, or any reputable lawyer. The fact of the matter is legal aid is there for those who need it, and I mean, the first thing that crosses my mind is if this chap is prepared to give a bonus or something, he probably doesn't need legal aid, but you can't do that.
I think it's important to highlight that what we're talking about is distinct from what Arnie Schwartz mentioned to you this morning, which is the situation where a client originally comes in and retains the lawyer privately and runs out of private funds, and at that point has to go to legal aid to obtain a certificate to carry on the work. That was the scenario that Arnie Schwartz was discussing and pointing out to you, that in that situation, the fact that the lawyer has previously taken private funds must be disclosed on the legal aid certificate. That is as distinct from the situation that Stephen has just addressed, where the client comes to you with the legal aid certificate in place and in effect wants to supplement the legal aid certificate to try to persuade you to take the case by giving you private funds in addition. And that, as Stephen has pointed out, is most definitely prohibited, and clients must be instructed in no uncertain terms that that is not permitted. I know it has also been suggested in other settings that in any case where that proposition is put forward by a client or prospective client, you would be very wise to make a note to be placed on file, should it become an issue down the road, that this proposal was made by the client and was clearly rejected on your part. Alice, the next question I have concerns the scenario of a client who's switching counsel. And let's assume that a woman comes to your office one day and identifies herself as Tom Jones' new lawyer. You recognize the name Tom Jones as the name of a client of your firm. The woman now tells you that she has just been hired by Mr. Jones, who no longer wants your firm to represent him, and that she has come over to collect the contents of Mr. Jones' file from your firm. What do you do?
Well, first of all, you don't give it to her. Then you tell her that you need a written release from Mr. Jones saying to release the contents of the file to his new lawyer. Then I would give the file to the lawyer in our office whose client it was to go through the file, take out anything from the file that he or she deems should not be sent over to the new lawyer, and get an itemized receipt from the client, make an itemized list of what's in the file within reason, and if there's documents and things, get it signed by whoever picks up after you've got the release from the client, then get the receipt signed by, say, Mr. Jones' new lawyer's support staff or whoever's picking up the file, so that everything is on file and no one can come back to you after and say, you know, where's so-and-so out of my file.
I think the point Alice is making is a very valuable point to note, and that is that it sometimes happens that clients have provided you, for example, with documentation or with something that is intended to be a piece of evidence to be used in their defense at the proceedings. When the file is passed on from your firm to the new lawyer, it's often a good idea to have the client sign a form of direction or release that specifies the contents of what is being passed on, so that consequently there will never be any question that what you passed on included this very important item or piece of documentation that the client is relying on in support of his or her defense. Stephen, from time to time it unfortunately happens that lawyers' offices are visited by police officers who have in hand a search warrant to try to obtain files of clients who may be in difficulties with the police for all kinds of reasons. Is there anything that support staff should be aware of in terms of what they, first of all, should, and secondly, can do when that scenario occurs?
Well, to begin with, it may happen from time to time. I would like to think it's still a very rare occurrence, and it should be a rare occurrence because it strikes at the fundamental relationship between a lawyer and his client, in the sense that if this becomes something that's very prevalent, then people are going to be afraid to discuss matters with lawyers, to have files built up in the lawyers' offices. It really undermines the system, and generally speaking, and I think, you know, the courts are aware of that. Certainly, within the criminal code itself, there are provisions for that unusual occurrence. And what you should know is, if something like that happens, I think my first reaction, if I were the support staff, I would want to know where my lawyer is and how quickly the lawyer can be back in the office. I mean, you might be able to say to the police officer, you know, the lawyer is in court this morning, but will be back, you know, after lunch. You know, can you come back and exercise this search warrant or execute this search warrant at that point in time? The other thing you should know too, because it's such it sort of hits at this very fundamental issue as to privileged information. The Law Society is very interested in that, so you could certainly phone the Law Society, and should phone the Law Society, and they can have somebody attend at the law office. Ultimately, what will happen is if the warrant is being executed, that whatever is taken should be put in sealed packages. And it must be done in such a way that the police officer or officers, they're not reading this material as they're putting it in there. And in fact, I mean, it's very important that it's simply put away, and then you have under the code, I mean, at this point it's no longer in your hands, but an application can be made by the Crown, by the client, by the lawyer who acts for the client, to the court to argue the issue as to whether or not these sealed materials should be in fact opened up and disclosed in whatever process. But what you should do certainly is, I think in Toronto, where certainly the police force here is fairly sophisticated, I think things can be arranged ahead of time. I would think the lawyer might get a call from the Crown Attorney's office that this is going to take place, and you'd have stuff set up ahead of time. But if not, I think what you remember is you may want to call the Law Society, and you want to tell the police officer that the stuff is to be sealed and not looked at.
Should the support staff ever say to the police, no, I'm sorry, you can't take that?
No, I don't think you take that position. I mean, ultimately, if the police officer is going to do something that's just plain dumb and inappropriate, and remember, we're dealing with such a sort of a clash of some very fundamental principles. If it's shown at a subsequent application to deal with this material that the police officer acted in this way, you know, his efforts in trying to obtain this evidence is going to be thwarted.
I think it's important to appreciate that when the police show up with a search warrant, which is a document which is issued by a justice of the peace, that is a legal document on which the police are entitled to act. And if you attempt to obstruct the police in their execution of the warrant, for example, by refusing access to the client file area, you may well find yourself charged with a criminal offense such as obstructing justice. So As Stephen is indicating, from your perspective, the safer course is to follow the steps he's outlined. If the police won't comply with those steps, well, that's a matter for your principal to take up down the road with the prosecutorial authorities, but you shouldn't feel that it rests on your shoulders to try to stop or impede the police in their efforts to execute the warrant and seize the client files or documents. Alice, let's go back to the direct problem of clients again, and I want to ask you what would happen from your point of view in this situation. A client of your firm is charged with stealing cassette tapes. He comes to the office one day while all of the lawyers are out at court, and he's carrying with him a very large box, which he plunks down on your desk and tells you he would like to leave with you for the assistance of Mr. Sandler in representing him. You open up the box while the client is still there and find that, surprise, surprise, it's full of a bunch of cassette tapes. What do you do?
Well, first of all, we're always getting things delivered to our office from clients. If we were really worried about what was in the box, and I looked in the box, I guess my reaction would be to, and the client insisted that he leave the box, I'd say, well, I can accept the box on behalf of the lawyer, but I can't say the lawyer is going to keep the box. I would give it to the lawyer, say, you go through the box, you decide what you want to do with it. Because, you know, it could be a box of, you know, rock and roll tapes. I mean, I don't know. So I'd have to leave it up to the lawyer's judgment.
What would you do if it was perhaps not as subtle a situation? And let's say you know that the client is charged with murder, and he comes into the office and puts a blood-stained knife down on your desk and asks you to pass it on to Mr. Sandler for his use in defending him on his murder charge. What would you do then?
I would say I can't accept it.
And Stephen, in the event that the client says to Alice, well, that's too bad, and turns on his heel and walks out the door, leaving the knife behind, what should Alice do?
Oh, we're with the knife now.
We're with the knife now.
Well, I wouldn't touch the knife. You left the knife there, eh? I passed the problem on to your lawyer. But I think ultimately what somebody is going to have to do, whether it's Alice or the lawyer at that point in time, you're going to have to notify the Crown Attorney's Office that you have something that may well be material to the case.
And in your view, is that a step that Alice should take on her own? In other words, we talked earlier today about exercising initiative in certain situations. Should Alan exercise her own initiative and get on the phone and call the local Crown Attorney, or should she speak to one of the lawyers in the firm first?
I think in that circumstance, there's no, I think in that circumstance I would wait and speak to the lawyer. You've got, I mean, you can envisage different kinds of problems. I know when I was in private practice, there was a restaurant just downstairs from my office. Now, let's suppose there was a fight in that restaurant, and some fellow stabs another person and happens to know my law office is upstairs, runs upstairs with his knife and pops it on my desk, you know, or I'm not there and on the secretary's desk. Or worse yet, says, you know, I've stabbed somebody. What do I do with this? And the secretary says, I can't give you any legal advice because I can't, and the lawyer's not here. And the fellow then runs out with the knife in a very agitated state. Now, I think you've got a problem there. I don't know whether you can, I mean, I don't think you can simply just wait around for counsel to show up. In fact, you may be in a situation where you should be calling the police because you don't know this individual. You have, I suppose, some reason to believe that this person has committed a violent act, is still armed, and is now running down those stairs and going out amongst the public. I haven't had that situation.
So I guess maybe Marie Mountjoy was correct when she said when the lawyer isn't in the office, you should simply lock the door and and mind your own business. Stephen, let me ask you this question, which hopefully won't hit too close to home for too many people, but unfortunately does arise again from time to time. A lawyer wants to adjourn her client's case so that she, the lawyer, can go away on vacation. She prepares an affidavit in her secretary's name. The affidavit states that the reason for needing to adjourn the trial is that a defense witness is not available on the scheduled trial date. In fact, the secretary spoke to this prospective witness just last week and was assured by him that he would be there in court on the scheduled trial date. Should the secretary sign the affidavit that her principal has prepared?
No. Whatever your job description is, it doesn't include signing false affidavits. And you don't do it. Apart from the fact it's also an offense.
What if the principal responds to the secretary, well, I'm sorry, but if you're not prepared to do this, then I'm going to have to let you go from your position as my secretary?
Well, it's easy enough for me, I suppose, to sit up here and say don't do it. I think what you can tell the principal, first of all, let's assume that the principal is dealing with a competent and useful support staff. Lawyers don't want to see a turnover in their staff. Lawyers are comfortable with their staff. Presumably, the staff are functioning very well in the law firm. And if a lawyer gives you that kind of an approach, I think you can rightfully say to the lawyer, well, there is such a thing as wrongful dismissal. You're asking me to do something that's highly improper. I'm not going to do it, and I don't think that you have any cause to come on that way, and that's it. Now, if you are fired for that, then I think you have all kinds of ammunition, I suppose, if you want to call it that way, to deal with the lawyer.
Well, let's say that the secretary has refused to swear the affidavit and the lawyer has simply said, well, that's fine, I'll deal with it my own way, and has walked away. The following week, the secretary is doing some filing in the office, and lo and behold, what does she find sitting on her principal's desk but this very same affidavit, and to her horror, she realizes that somebody has signed that affidavit in her, the secretary's name. Then what does the secretary do?
Well, she certainly hasn't done anything wrong, or he. At that point in time, though, I think if there's another lawyer in the firm, you might want to advise the other lawyer of the situation.
Alice, do you have any thoughts on the matter? Not that I'm suggesting you've ever been put in that position, but do you have anything to suggest?
Well, actually, we went over this yesterday in the office, and that's exactly what came up. Just get independent legal advice if you really think, that something's been done wrong and you know about it, and like morally something's wrong, and you can't go to the Law Society because you're not, well, I'm not saying you can't, but you're not a member of the Law Society. So speak to another lawyer. Get independent advice.
And when you say independent advice, again, so that it's clear, are you referring to another lawyer within that same firm, or are you referring to a lawyer outside the firm?
I guess, I don't really know. I guess independent is outside the firm.
Yeah, generally, although when we come to some of the other questions, we may have a slightly different approach. I think generally when one thinks in terms of independent legal advice, it's wise to think in terms of somebody outside the firm just to avoid potential conflicts down the road. But again, as I'm sure you can appreciate, with all of these scenarios, much of what you decide to do is a judgment call, which time may prove was the correct judgment call or may prove wasn't quite the correct judgment call. But I think Alice's suggestion to you to get independent legal advice is a very valid suggestion to keep in the back of your mind if you're ever in the unfortunate position of feeling that you're being put in a position where you have sensed some impropriety or perhaps are being asked to engage in some impropriety.
I'd also suggest that if you're not sure, just make a memo of everything that's happening, so you're sort of covering yourself. You can remember exactly what happened.
Let's Alice, if I can just move you on then to a slightly different situation. Again, getting back to dealing with clients. A client calls the office and wants to know, has the lawyer you work for prepared his case for trial yet? The trial is starting next week, and the client expects that everything should be prepared and ready to go. In fact, you know that the lawyer has been very busy and hasn't even opened up the client's file, and that no preparation whatsoever has been done. What do you tell that client?
Well, I would say I'll let you speak to the lawyer, even if the lawyer has to get back to them, because I really don't know for sure if anything's been done or not. But it's really up to the lawyer to speak to the client and tell them how much work has been done on a file, not up to support staff.
Stephen, what about this situation? A lawyer tells his secretary to send an account to a client showing that certain work was done the previous Monday when he, the lawyer, removed $5,000 of the retainer from the client's monies held in trust. In fact, the secretary knows the work has not been done. What should the secretary do?
Well, she shouldn't do what the lawyer is asking her to do. What the lawyer has done is misappropriate funds and is asking the secretary to cover that up. I mean, it may be a situation where on the Monday the lawyer didn't do the work and has subsequently done the work. It's still wrong, and you don't backdate it because at that time the taking of the funds from the trust account was improper. It was misappropriation. And that's my advice to the secretary. And of course, you run into those situations again. Is the lawyer going to put pressure on you or not? And then I think you have to handle it as we had discussed in some of the earlier hypothetical situations.
Unfortunately, it does happen from time to time that lawyers misappropriate funds from trust accounts, and often in the background there is a member of the support staff who perhaps has been an unwitting dupe in what has been going on. So not that I think you should mistrust your principles, but on the other hand, it is wise to bear in mind generally what Stephen is saying, that it is not proper or appropriate to backdate accounts. This is one area where, when Stephen and Alice and I had some discussion about the problem earlier, my own personal view was that if I were a partner in this firm, I would want the member of the support staff involved to come to me and apprise me of the situation and put it in my hands to deal with the lawyer who was instructing that the account be backdated, because I think that to some extent there is an onus on partners within a law firm to know what is going on with the administration of the bank accounts, and to a large extent the Law Society has told us that as partners within a law firm we have an onus to make sure we know what is going on with clients' trust accounts. So my personal view is that you certainly could never go wrong if you felt uncomfortable in going and discussing the matter with another principal in the firm. Alice, let's assume that your firm has a client who is charged with fraud. He has been released from custody on bail. You work in a very busy office and you can't possibly know what is happening with each and every client's file, and you don't know the particular conditions of the bail order. All you know is that a copy of the release papers, the bail papers, are in the client's file. The client telephones you one day and says to you, well, I've changed my address and here's my new residence. You assume the client is just calling you as a courtesy to let you know. You make a note of the new address on the office file cards in the office record system, and you don't mention the call to the lawyer for whom you work. Is there any potential difficulty in not going further than that?
We always leave a note for the lawyer of a new address and a new telephone number of a client. And I think everybody should, each lawyer should be notified just because of that happening. Because I don't always know if there's a bail order in a file, because we got so many files. But definitely leave a note for the lawyer.
The concern, of course, is that a very common condition in bail orders is that the client reside at a particular address and that notification be given to a police officer or to a court office of any change in that address. if the matter isn't brought to the lawyer's attention when the client phones the office, it may well be that that court officer, that police officer is never advised of the change in address. The next thing that happens is the client is arrested for breaching his or her bail condition, and all of a sudden you as a support person are put on the spot because you've had the misfortune to take the client's telephone call when he reported the information. Stephen, let's assume that a police officer now calls a lawyer's office and wants to know if the lawyer will consent to an adjournment of a trial date, which is being requested by the Crown Attorney because the police officer is not available on that scheduled trial date. The lawyer is out of the office at court. The support staff is trying to be helpful and immediately tells the police officer, I'm sure there won't be any difficulty. Ms. Smith always consents to adjournments requested by the Crown. Go ahead and tell the Crown Attorney that she can reschedule the case to a new trial date. Is there any difficulty there?
Yes, the support staff clearly should not do that. It's the client's trial date. It's not the support staff's or the lawyers for that matter. Apparently there are no instructions here from the client to consent to an adjournment. We don't know why the police officer is not available. Usually when they set trial dates, the Crown prosecutor has on the dope sheet leave times for the police officer. It may not be an appropriate reason for the adjournment. You can run into problems that are encompassed by such famous cases now as Ascov. You clearly don't do it. You can't, you can be polite about it, but you haven't got the authority to consent to that adjournment.
Are there any questions from the floor? Stephanie?
If a lawyer is backdating an account, taking money out of the trust account, and he's a sole practitioner, what would you suggest that they do in that case?
Stephen, do you want to deal with that?
Well, the lawyer is doing something that's improper. I mean, that situation doesn't change. You, as the support staff, are not required by your job description to go along with something that's improper. So, and I would still indicate to you that you don't participate or assist the lawyer in that respect. And you can advise the lawyer that you think it's highly improper. If the lawyer is going to fire you because of that, if that's what your main concern is, again, there are all kinds of people you probably are going to want to speak to. At that point, certainly, even before, you may wish to speak to the Law Society. You're under no obligation to speak to the Law Society. I can tell you the Law Society would be very interested in that situation, and it would ultimately, I would think, trickle down to my desk relatively quickly. And unfortunately, I have to, from time to time, deal with misappropriation cases before discipline tribunals and before convocation, and they're dealt with very severely. You're welcome.
Yes. The question being posed is whether it's appropriate for support staff to accept gifts from clients and whether there should be a distinction made between flowers or a box of chocolates given at the completion of a case by a grateful client on the one hand and the proffer of funds such as $100 to the support staff by the client on the other. Alice, does your office have any policy about gifts to support staff from clients?
We don't really get any. No. It's never been a problem. Sometimes the lawyers have gotten plants and that, and they just write a letter, phone the client, say thanks, and at Christmas they'll get a fruit basket and they phone and say thanks, and that's about it.
Stephen, do you see a distinction between flowers and chocolates on the one hand and cash gifts on the other?
Well, from the position I'm now holding as discipline counsel, I'm not sure whether I'm particularly interested in it vis-a-vis the support staff one way or the other. I mean, I sort of, what's going through my mind, am I looking at some kind of fee splitting or improper bonus? No, I really don't, I don't see any difference particularly. It's a gift.
From my own perspective, I think that if it happened in my office, and since my secretary is here and you'll be hearing from her later, you can feel free to ask her if a client has ever offered her money, but I never have a problem with a grateful client giving a gift to a member of our support staff. I think it's, in a sense, appreciated that clients do recognize that the support staff play an integral part in their representation, and in fact to a large extent often play a role in the resolution of the case. But I personally would prefer to be told by my secretary or another member of the support staff if the gift that had been offered was a gift of cash, because I think what might be more appropriate in that scenario would be for the lawyer to suggest to the client that it's very nice for you to attempt to show your appreciation, but perhaps it would be more appropriate for you to send flowers or bring a box of chocolates or something of that sense, as opposed to giving a cash gift. Again, it's an interesting question, because certainly within some cultural groups, a gift of cash, I appreciate, is considered to be an appropriate way to express gratitude. And so to some extent, I think one has to sit back and try to evaluate whether this is a client who is just trying to express gratitude in a way that he or she thinks is appropriate, and a client who perhaps thinks that he or she is doing something more than that. Told that she should have accepted it. Yes. The issue that's being raised is what one can do in terms of gifts at seasonal times, for example, to government offices and agencies such as court offices. And I think that most of the court offices in Ontario now operate pursuant to a directive that they are not to receive gifts at Christmas time, perhaps with some slight exceptions if it's something like a box of chocolates intended for the entire office to consume. And that in part is because of certain provisions in the criminal code and certain case law that has developed as to what is treated as a form of benefit that is in fact prohibited by the criminal code. That, yes, the problem is that it may be misinterpreted. I know that certainly when I started articling 13 years ago, it was quite common at Christmas time for lawyers to express their appreciation to court staff and Crown Attorney's offices for their assistance during the year by making a small gift of chocolates or perhaps a bottle of liquor or something of that sense. But I myself am aware that in the past 13 years the rules have changed and that one has to be very careful about that. So I think that perhaps unless you know from the court staff that they feel comfortable with it, it's better left undone. Yes? It's being indicated from someone from a government office that at Christmas time and Easter gifts have been received from defense counsel. So, yes. Yeah. Yes. The question that's being posed has to do with information being given by support staff to the press and whether or not it's appropriate if a journalist calls you on the phone and wants to know, is your principal in court doing Mrs. X's trial today, whether it's appropriate for you to answer that question. Again, I think that it's a judgment call and that you need to check with your individual principals. Thinking in terms of the clients within our office, most of them do not appreciate information being given by members of our staff or the lawyers in the firm about the status of their cases, including which days they may or may not be in court for various proceedings. So I think that one has to be governed by what your own principal feels comfortable with. Yes? The comment has been made that perhaps it's best to avoid giving out gratuitous information in any situations because, among other concerns, you can't always be sure who it is who's on the other end of the telephone. Yes? It's being pointed out that you, as a member of a law firm, may be being used by the press or the media as a shortcut, and that if the information they want, in fact, is a matter of public record, such as a court date or a court appearance, that they have means of obtaining that information from the appropriate court offices. Yes? The question has to do with the extent of solicitor-client privilege, and the scenario that's specifically being put forward is that of the client whose driver's license is under suspension, and you become aware that in fact he's been driving back and forth down to the lawyer's office, or the client who comes into the office who is subject to a prohibition order that he will not be in possession of weapons and is carrying a knife with him. And I think your specific question was, what is the obligation of the lawyer in those circumstances? Stephen?
Well, if the obligation stops short of criminal activity, I mean, if he's in possession of cocaine, or if he is committing an offense by driving when you know he shouldn't be driving, I don't think that the privilege goes that far.
Anybody else? Yes.
Going back to the nice scenario where the guy comes in with like nice face and all that. If he comes in and says, "Do you want to take it or take this? I'll give it to the lawyer," and you say, "I don't want it," and don't want to take it away. If they leave the office, aren't you kind of assisting them in concealing evidence, or like, isn't there
The question goes back to the scenario of the client who comes into your office with the bloodied knife, and it's being suggested that if you simply say to the client, I can't take it here, take it away with you, that it may end up being disposed of somewhere, as opposed to if you accept it and pass it on to the lawyer, it may end up in the hands of the authorities via the Crown Attorney. Stephen, do you have any comment on that?
Well, if the individual leaves the knife on the table, and I think if I were in your position, I would say I have no authority to say to you that the lawyer, what the lawyer will do with that, whether he's going to take it into possession or not, and I don't know if I'd go any further with that. In terms of protecting evidence, I don't think if I were you, I'd drape myself over that knife so that he couldn't go pick it up again. I mean, you're liable to get yourself into some very serious trouble. Practically speaking, if the individual walks away with the knife, then he walks away with the knife. But I think what will follow is once the lawyer is there, the lawyer is compelled to, we're talking about an individual who's already retained the lawyer?
Yes.
Well, the lawyer will ultimately tell this individual that the knife, you know, it can't get lost now. It's going to have to be, assuming we're dealing with an offense that involves a knife. We don't know whether it's this knife, but there's a lot of reasons why you may want to draw an inference. But that's going to be disclosed, and whatever tack you're taking in terms of a defense is going to be perhaps altered because of that.
So just let him leave, and when the lawyer comes in at the end of the day after court, oh, by the way, he had a knife.
Yeah, you'll surprise the lawyer, but yeah, I don't think you're there to confront an individual in circumstances where he or she is armed with a knife, even if they put it on the table.
Just an average day at the office. All right, thank you. We're going to take another quick 15-minute refreshment break and then come back and talk about preparation of appeals.